Hello and welcome to Runkle to the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Alec Baldwin's trial in the shooting death of Helena Hutchins on the Rust set is starting soon, and once it does, I'll be doing gavel-to-gavel coverage. If I can, I'll also do recaps, so I might be a little busy. But before we get there, I wanted to cover a motion in limine that's been filed in this case. That's a motion in advance of the trial, and this one is a bit wild, a bit spicy. I don't think I've seen anything like it, so let's have a look. This is defendant Alec Baldwin's motion in limine to preclude improper prosecutorial conduct and require an orderly trial. Okay, that's interesting. To preclude improper prosecutorial conduct. Let's have a look at this. So defendant Alec Baldwin, by and through his attorneys, submits this motion in limine to preclude argument, testimony, evidence, and statements that violate courtroom rules and prosecutorial standards of conduct. Now, here's the thing. If they violate courtroom rules and prosecutorial standards of conduct, why do you need a motion in advance to bar that? Normally, that would be something you could object to ahead of time, especially when they don't have any sort of specific evidence here that they're looking at, but more kind of styles of evidence or these kinds of things. Now, some of the things, well, most of the things that they're talking about are violating courtroom rules or prosecutorial standards of conduct, with, I think, one exception, so we'll get to that. So, including, by way of example, disguised or subtle remarks about Baldwin's fame or wealth, improper burden shifting, vouching for the opinion of the state, urging the jury to reach a verdict based on anything other than the evidence, and coaching witnesses. Okay. So, argument. Special Prosecutor Carrie Morrissey, a veteran criminal defense lawyer, now represents the state of New Mexico. Accordingly, she must now adhere to the ethical responsibilities and standards of conduct that accompany that role. And so they're going to be a little poetic here as they quote from a couple of cases. First one says, a prosecutor is not simply acting as counsel for one of two parties in a dispute. She is acting on behalf of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all. And another quote, while a prosecutor may strike hard blows, she is not at liberty to strike foul ones. I'd agree with these quotes, generally speaking. They're good quotes. Because of the inherent confidence an average jury will likely have in an agent of the government, improper suggestions, insinuations, and especially assertions of personal knowledge are apt to carry much more weight against the accused when they should properly carry none. Morrissey, who may be overly accustomed to the leniency granted to counsel for criminal defendants, fell well short of these standards throughout the trial of Hannah Gutierrez Reed. Now, I'm just going to note, these are not lawyers for Hannah Gutierrez Reed. Hannah Gutierrez Reed is really just irrelevant to this trial. They don't have standing to litigate Hannah Gutierrez Reed. But essentially the argument is going to be, listen, we don't like what happened in the Hannah Gutierrez Reed trial. You need to preemptively say she can't do those things in this trial. And we'll talk about that too. And there's no indication from the state that it intends to approach Baldwin's trial any differently. Yeah, but there's no indication that they don't. This court has a critical role to play in upholding principles of prosecutorial integrity to protect Baldwin's due process rights. The court should be particularly mindful of the following concerns. Okay, so they're basically trying to put the court on notice, but I think this is a little unusual because normally you would object to these things as they come up, as opposed to saying, like, we need you to bar these things that are already barred. So this is strange to me. So it's improper for the state to distort the burden of proof in any manner, or to make arguments and statements that improperly lower the state's burden of proof. So let's talk about the state's burden of proof. The state is the entity that wants to punish somebody or to throw someone in jail. And we don't allow that lightly. In fact, the standard for that is proof beyond a reasonable doubt. This is a high standard. It's not more likely than not. It's not even really likely or pretty sure or anything like that. A lot of our decisions that we make in ordinary life might be made on a standard of, pretty sure, but not beyond a reasonable doubt. So, as an example, let's say you're sleeping and you hear a noise upstairs. You might be pretty sure it's your dog, but it's probably not beyond a reasonable doubt unless you go and check. So, kind of these thoughts. One way a prosecutor can do this is to suggest that the jury should determine facts, determine the facts from the evidence not produced. So, as an example, let's imagine that you've got a witness who, an accused who says, "I have an alibi. I couldn't have done it because I was in, Detroit, and the crime is not in Detroit." And then the prosecutor says, "Well, they said this, but did we see any plane tickets? Did we see any bus tickets? Did we see any hotel fares? Did we see any of these things?" No, so hasn't been proven. They don't have to prove that. It's actually that the prosecution has to disprove it. And so they might, for instance, disprove it by investigating and having evidence that there was no plane ticket, there was no bus trip, there was no gas purchases, and then you've got actual evidence of the absence of something. So you can't sort of demand this, right? Again, let's imagine that there's a burglary and there's no actual evidence called at the burglary to show who committed the crime. There's no fingerprints, there's no DNA, there's no eyewitness. And so the prosecution, when the defense probably quite properly is going, "We have no idea who did it," they would say things like, "Why haven't you heard from any witnesses who saw this person not committing the burglary at this time? Why haven't you heard from this person saying that they didn't commit it?" That's not fair. That's not how the trial is supposed to work. That's improper. But they're going to say that this is something that happened in the Gutierrez-Reed trial. So they say, "Yet the state did exactly this during the Gutierrez-Reed trial." So, Bowles, what evidence do you have? And then later, Morrissey says, "Has the defense filed any kind of motion in this case to try to get to the full contents of his phone?" And then Morrissey, "Okay, and you agree with me that defense counsel is free to issue subpoenas and file motions to compel and do all of these things in a case if they feel that they're missing evidence?" Okay. And then, "But this man is not a mystery to the state or the defense. I made him come in and sit down for a 1.5-hour interview so the defense could ask him any questions they wanted, and they asked him none. Not a single question. So what that means that this is all just smoke and mirrors and deflection. Comments like these, which impermissibly shift the burden onto the defendant, are patently improper as they violate the sacrosanct rule that every criminal defendant remains innocent until proven guilty." Now, if you remember the coverage and the discussions during the Hannah Gutierrez-Reed trial, a lot of us were shouting, "Object, Bowles, object," at various points. And Bowles was not so great at objecting to things. So, yeah, some of these may have been improper. Some of them not as much. I agree with them on some of these quotes and less so on others, but that really doesn't matter here as much as the fact that unless Bowles is objecting, things go in. You've got an obligation to object. And I don't think that there's any indication that these lawyers are going to have any problem objecting. Certainly, they're objecting to things in Hannah's trial before Baldwin's trials even started. So, I think they're gonna find their objections. But let's continue on. The state has already signaled that it intends to pursue similar tactics at Baldwin's trial. For example, in a pretrial interview of one of the state's witnesses conducted by Baldwin's counsel, Morrissey ended the interview as follows: "You haven't been asked any questions today about Mr. Baldwin's conduct on the movie set of Rust, is that right? And so no one has made any inquiry to you today of what you may testify to in trial regarding Mr. Baldwin, is that right?" when comments like these are made in front of a jury, which it wasn't. Like, this is not in front of a jury. This is a pretrial interview. So that's a very different thing, right? Jurors can easily be misled into thinking that the defense must put on a certain type of case, or any case at all, to be entitled to the presumption of innocence. I mean, there's an obvious difference between a pre-trial interview versus the case in front of a jury. And the fact that you do something outside of the presence of the jury doesn't mean you're going to do it in the presence of the jury. This seems really a stretch here. Attempts to improperly shift the burden in this manner are particularly dangerous where the state has repeatedly reminded jurors and for the public at large how many lawyers the defendant can afford to hire for his defense. See example, Exhibit D. There are 2 lawyers on the state side, there are 10 lawyers on the defendant's side, and they have at least 1 investigator. So if they can't get that under control relatively quickly, I'm not sure what to say. Now, this was not actually reminding the jurors or the public at large how many lawyers the defendant can afford. This was actually during a retrial motion where they're saying, listen, they should be able to handle this in the amount of time they have because they've got a lot of people on it. That's, again, not the same thing as reminding the jury. This doesn't work for me. I would have comments about this particular bit here if I was the judge. Those comments might be loud and they might be very pointed. So, the court should enter an order precluding the state from engaging in any improper burden shifting, including when it involves comments about Baldwin's defense strategy or Baldwin's counsel. So, especially they don't want, any mention of Baldwin's got a lot of lawyers. But there's not actually been any indication that she would do that in front of the jury. So I don't know why they're actually asking for this here. And if there's a comment you don't like that's made at trial, normally the way you deal with this is you object to it when it's made. That's just how things are done. So on to vouching for the opinion of the state. A prosecutor's vouching for the credibility of witnesses and expressing his personal opinion concerning the guilt of the accused pose 2 dangers. Such comments can convey the impression that evidence not presented to the jury, but known to the prosecutor, supports the charges against the defendant, and thus can jeopardize the defendant's right to be tried solely on the basis of the evidence presented to the jury, and the prosecutor's opinion carries with it the imprimatur of the government and may induce the jury to trust the government's judgment rather than its own view of the evidence. So during closing argument in the Gutierrez retrial, Special Prosecutor Morrissey violated this principle by expressing her personal views on various elements of the case. She told the jury, "We know the truth. You've seen it throughout this trial." Now, I think the "we" is it's referring to, we as in the jury as well, right? I don't think that that was intended as we, the government, know the truth. It's you guys know what's going on. And I will remind you that during one of the heated objection exchanges between myself and Mr. Bowles, you heard Mr. Bowles cry out that he was looking for the truth. Listen, I can bring a horse to water, but I cannot make him drink. Okay, now what was Bowles' response? Did he object to that? I don't recall him doing so, so that's the thing. You object to these things if they're objectionable. She further told the jury that her job is to tell them her opinion on critical elements of this case. If you think that person would have done a satisfactory safety check if she had been called back to the church, I am here to tell you that I strongly disagree. Okay, again, object to these things if they come up. So, there can be no excuse for such conduct. State versus Vallejos. Recognizing that as improper, comments that essentially use the prosecutor's position to express a personal opinion on the defendant's guilt or innocence. Okay, so you have objections to things that happened in Hannah's trial. That would be great if you were Hannah's counsel and if this was contemporaneous, but you're going to have a completely different trial where you will have the ability to object in your trial. This all is very odd. For the same reasons, a prosecutor may not use their role or their ability to interject their own opinions as to the true answers to defense counsel's questions. Morrissey did this regularly at the Gutierrez-Reed trial, using her role to testify to the jury, impede the defense examination, speak up about her own role in the case, and interject her own opinions where they do not belong. Really, what they should be saying is, listen, we don't want speaking objections here. But instead, they're kind of throwing a lot of shade towards Morrissey. And I'll note, Bowles and Morrissey both did a lot of speaking objection and so forth. And the court permitted it right up until the court got tired of it, which was proper. So, objection, that misstates the facts that are already in evidence. The court let him answer the question. And then Morrissey, I will object to the form of the... misstates facts is actually a proper objection, but the court let him answer the question. Morrissey, I will object to the form of the question. It is completely contrary to the evidence that the jury has heard, and Mr. Bowles knows it. Now, they did get into a whole bunch of improper objecting during this trial, and a whole bunch of improper responses and so forth, until the judge finally put her foot down. Fair, but to characterize this the way they have is a little off, I think. So, and then Morrissey, well, if he's mentioning me, I don't know what he's talking about. Indeed, the prosecution's objections became so heated that the court had to admonish the prosecution that it's not advisable to get that upset in front of the jury, urging the prosecution to approach for objections rather than to yell it out from counsel table. And eventually the judge actually did get the courtroom under control, and I suspect that the judge would approach things having learned that lesson in the Baldwin trial, and basically just say, object, approach, instead of object and speaking objections, which was going on a lot. They also note, likewise, it is improper for an investigative agent to be seated at counsel table throughout the trial to bolster the prosecution's credibility or authority. At minimum, if an investigative agent who is a witness in the case is permitted to sit at counsel table throughout the trial, that witness should be required to testify first. And, okay, they're objecting there to the one detective who was frequently sitting up front. So, the state must not be permitted to use its role and the heightened credibility that carries with the jury to vouch for its own opinions on the witnesses, the evidence, or the ultimate issues the jury must decide, nor may it be permitted to undermine the norms of courtroom decorum that allow each side to present its own evidence. Doing so fundamentally undermines the defendant's constitutional right to a fair trial. And again, there's a remedy for this, which is objecting. That's normally how you deal with these things. So, coaching witnesses. It is improper for any attorney, particularly an attorney representing the state, to advise a witness to testify falsely or to phrase a witness's testimony. Now, note this. Advise a witness to testify falsely or to phrase a witness's testimony. Okay, now they say the prosecution crossed these lines at times during the Gutierrez-Reed trial, and they're going to offer some evidence of this that, in my opinion, is real thin. So, Morrissey, and when you met with me, did I tell you what to say? Corporal Hancock, we talked about what was going to be discussed. Morrissey, did I tell you what testimony to give? Corporal Hancock, yes. Now, she goes on to say that basically she was told to tell the truth, and she was never advised to lie, but that's not quoted here because that part isn't helpful. So, I don't know that they get to testify falsely. I would say that on the evidence, they certainly don't get there because the next questions or the answers to the next questions are, no, you didn't tell me to lie. Or to phrase a witness's testimony. We don't really get there. It might be, hey, I need you to talk about these things. These are the questions I'm going to ask. But and this might have been something that they could have gotten out on cross-examination if Bowles had explored that. What exactly did she say to tell you? But I don't think we actually have that evidence here. So they note, and it has crossed the line on numerous occasions throughout these proceedings. Okay. To protect Baldwin's fundamental due process rights, the court should preclude the state from engaging in similarly improper conduct at trial. And they have a citation here for the disturbing revelations of the state's improper witness coaching during Friday's cross-examination of FBI agent Ziegler reinforced the need for the relief sought in this motion. As the court will recall, cross-examination revealed that Ziegler had met with the special prosecutors and their paid expert witness last week, something Ziegler had never done in his entire career, so they could come up with new... Now, they met with... Yes. Now, at this part, we're getting into more allegations and shade as opposed to anything they've proven. So they could come up with new, fabricated testimony about Ziegler's gun testing that could explain the contradictions between Lucien Haig's false testimony in the pretrial interview that there were no modifications to the gun, as well as the state's similar representations of the court that the FBI testing caused any and all perceived modifications, and Haig's third belatedly disclosed expert report stating that the FBI's testing did not cause the modifications of the working surface of the hammer/sear. Okay. I don't think that they've actually established any of that, and yeah. Baldwin reserves all rights to pursue other relief related to this wildly unacceptable misconduct. I don't actually think it's helping Baldwin's team that everything that they do is always at 11. Like, every issue is always, like, intentional misconduct, and every issue is always, this is the worst thing ever. There's a need to advocate zealously for your client, but if you're losing credibility in the process, that's not fantastic. Certainly, they have been arguing intentional misconduct and the worst thing ever on various motions pre-trial, and they've not had a whole lot of success with it. So maybe dial it back. Okay. All right. Urging the jury to reach a verdict based on anything other than evidence. So, because the sole duty of a prosecutor is to see that justice is done, prosecutorial commentary that urges a jury to convict for reasons other than the evidence defies the law and undermines the integrity of a verdict. Arguments urging the jury to send a message with their verdict or to protect people like the victim fall squarely into this category. This kind of pandering is at best unprofessional. At worst, it places in jeopardy an otherwise just verdict. The state should be precluded from making any such arguments here. Now, you'll note they didn't actually say that, right? They don't actually have any citations for this. I don't know what they're suggesting that Morrissey's going to do. Because then they just move on to conclusion. For the above reasons, the court should preclude argument, testimony, evidence, and statements that violate courtroom rules and prosecutorial standards of conduct, including, by way of example, disguised or subtle remarks about Baldwin's fame or wealth, improper burden shifting, vouching for the opinion of the state, urging the jury to reach a verdict based on anything other than the evidence, and coaching witnesses. Now, if you've been checking along at home, if you've been doing like a little ticking the boxes as you go, you'll notice that they made arguments based on improper burden shifting, vouching for the opinion of the state, urging the jury to reach a verdict based on anything other than the evidence, and coaching witnesses, although the anything other than the evidence argument was pretty thin. What they didn't actually make submissions about at all was disguised or subtle remarks about Baldwin's fame or wealth. That they just kind of slip in there without making any arguments about it. And that is really, really interesting, because that's actually the issue that I think they're weakest on, and that because that's actually something that may well be relevant in this case. Baldwin is saying, hey, I'm just an actor. I don't know, anything about what's going on. I barely know how I got here. What am I supposed to do? But his fame and his wealth play a role in things, or at least are alleged to, because One of the things that the prosecution seems to be planning as part of their trial strategy is to note that Baldwin was able to circumvent the safety training, and did circumvent the safety training and the safety rules because he has clout. He's got the ability to do so. Certainly, if your role in the film is like bandit number 7, that's how you're going to be credited at the end of the film, is bandit number 7. You're not even bandit number 1. You certainly aren't getting a name. If you blow off the safety training, you're probably also blowing off your paycheck. And your paycheck certainly isn't going to be Baldwin level, but you know, you're blowing off your paycheck if you decide to skip the safety training. Certainly if you were like, hey, instead of doing the safety training, how about I play with guns and film a little clip of me playing with the guns to send to my kids? Yeah, you would probably never work again. Baldwin's fame and wealth and the power and authority they give him on this particular film set may actually be incredibly relevant. And so they slip in like, please don't make any mentions of Baldwin's fame or wealth. And yet, I think that's actually going to be a really relevant issue in terms of how did this accident happen. We may actually see in training for armorers issues of, listen, just because the actor is a big name doesn't mean that they can cut corners. So that's kind of a thing there. So it's interesting that they kind of ask for that, but they don't make any arguments to support it. I thought that was real interesting. The other thing is, how would the jurors possibly infer about Baldwin's fame or wealth? I mean, is there some possibility that they could have heard of Alec Baldwin? I mean, I think that's going to be a thing. But the other thing that they'll notice, even if they somehow forget that Alec Baldwin is an actor and so forth, if they somehow forget that, I imagine there's going to be other subtle cues, like Alec Baldwin's team basically looking like a football team instead of like a legal team, just based on numbers. So they may subtly pick up on that. And I don't think there's any motion in Limine that you can bring that'll stop jurors from observing that. Baldwin may also have his own choices as to how he dresses. If he wants to not emphasize his wealth, he may want to buy a suit off the rack, or maybe, you know, a $2,000 suit instead of a $20,000 suit. That'll be an option he's got. Up to him. But the issues of how his fame and his wealth may have allowed him to circumvent safety rules, or to, you know, have special rules applied to him that didn't apply to anyone else, may very, very well play into the prosecution's theory in a legitimate way. Now, certainly there's illegitimate ways that they could use this. If there's a suggestion that they should, you know, punish Baldwin for being wealthy, that would be improper. If there's a suggestion that Baldwin is less credible because he's famous, you know, oh, those Hollywood guys, you can't believe anything out of their mouths, that wouldn't be appropriate, right? So we'll see. I don't expect this motion to go very far. I expect the judge's response will be something similar to my initial response, which is, you can object whenever you want. You can object at trial, and we'll rule on those objections. I do hope that the judge is going to, in this trial, be a little more careful about reining in the speaking objections, so that people can be like, objection, you know, objection, hearsay. And then if they want to argue about it, they can come up and speak at the bench instead of in front of the jury. That's proper. But we'll see. I just thought that this was a bit of an unusual motion, so I wanted to talk about it with you guys. And certainly it presents to us the likely outcome that the trial is gonna be spicy. I don't think the defense team likes Ms. Morrissey at all. I doubt Ms. Morrissey likes them any better based on these kinds of things being thrown around. And it looks like a fair amount of the arguing is going to be not necessarily for the jury, but for you and I, the people at home. I think that this motion may be in part directed towards those of us here at home who are maybe drawing our own conclusions. So anyway, stay tuned. As I said, I'll be doing gavel to gavel coverage, as well as, if I can, if I've got enough energy, we'll do recaps. But thank you guys for watching. I hope you found this to be interesting or educational. If you like this, please hit the like button, hit the share button, hit the subscribe button. All of those buttons do good things. I also want to thank my Patreon supporters. You can hear my pup in the background who wants me to wrap this up so that I can let him outside. Hey, Potter. And he is not actually on my Patreon supporter list, but you can be. At the $50 level, Canada's National Firearms Association, PJs Forever, CCFR, and the Canadian Shooting Sports Association, as well as Cielo and Purple Dragonair. At the $20 level, we have Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunk All of the Baileys, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. I will, the $10 supporters will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. I gotta go let a dog out. See you next time.